What's up, viewers, subscribers, and agents alike? This your boy, Luciferian Prince, coming at you once again with another upload. I want to start off by saying people who have emailed me, if you email me specific questions, I'm going to say this again. One more time. Whenever you email me with regards to certain questions, please be specific and let me know in the email description if you would like to schedule a consultation. Those questions on the private side have to be addressed because there might be a period of time that has to be spent in which you're going to need proper understanding. If indeed you don't wish to do that, don't become upset when I don't respond to your email. It's just that easy. In another sense, I told you in my previous upload that this is going to be a groundbreaker, which indeed it is to those who know the jewels in which I'm getting ready to expound upon, and they know that what I'm getting ready to say, what I'm getting ready to elaborate upon, will also be looked at in its proper context. Now, to the people who don't particularly catch what I'm saying, please do your research, study it thoroughly. You understand exactly what I'm saying is very true. If indeed you don't get that concept, that what I'm saying is very true, and that means that you're just going to have to do a lot more studying. It's just that simple. Now, we're going to talk about how a law of the Jews became the law of the land. Now, historically, and primarily for those people who have done their extensive research in history in regards to the messianic figure in his time, who came to reestablish natural law, whom the manipulators at his day and time and era were still operating in the same capacity, didn't want natural law restored. So they put him to death as, quote unquote, an enemy of the state. However, religious dogma has often made people believe that because the individual came and he came particularly to have a specific purpose and to have, this divinity of, so to speak. We'll get on that topic later. It might upset some people's beliefs, but in regards to what I know, what I have actual documented evidence on, trust me, be prepared to become upset because the truth often does upset people. Now, back to what I was saying. The Mosaic Law, what they say, the rabbinical law, according to the ancient, Jewish law that pretty much has been passed down. We're not going to say Jewish because it has been converted from the law of Israel to the law of the Jews. The Jews are not Israel. Israel's a people, and the Jews consider themselves to actually be descendants of Israel, and they also have usurped, the birthright of Jacob. And particularly what they do is they have used it in such a manipulative sense that they feel as if they are the divinely chosen. And we know, according to history, Revelations 2:19 says, the Jews who say they're Jews and they're not, we'll get into that later, but particularly they usurp the birthright to otherwise manipulate the world into believing that they are the be-all, end-all to society. So, without further ado, let's get into a very good topic, one I wish to like to talk about: history, law, facts included, and much more. To this is the actual source which I'm reading from. Like I said before, a lot of stuff I just note in my videos, but because people have done things yesteryear, a lot of things I just don't say out publicly because it is what it is. For every truth, there will often be a duplicative lie. Here we go. Intro. English law, like the English language, is an amalgam of diverse cultural influences. The legal system may fairly be seen as a composite of discrete elements from disparate sources. After the conquest of 1066, the Normans imposed on the English an officially organized social system that crowded out many Anglo-Saxon traditions. The Jews, whom the Normans brought to England, in their return contributed to this challenge in English society. They're also known as the Khazarians, not Israel. Remember, Israel's a people, not a place. The Jews brought a refined system of commercial law, their own form of commerce, into a system of rules to facilitate and govern it. These rules made their way into the developing structure of English law. Several elements of historical Jewish legal practice have been integrated into the English legal system. Notable amongst these is the written credit agreement, also known as the Shetar, as it appears in English documents, or as star. The basis of the Shetar, or what is known as the Jewish gauge, was a lien on all property, including realty, that has been traced as a source of origin in the modern mortgage. Under Jewish law, the Shetar permitted a creditor to proceed against all the goods and land of defaulting debtors. Both movable and immovable property were subject to distraint. In contrast, the obligation of client service under Anglo-Norman law barred a land transfer that would have imposed a new tenant, and therefore a different kind of knight owing service upon the lord. The dominance of personal feudal loyalties equally forbade the attachment of land in satisfaction of a debt. Only in the debtor's chattels could it be seized. These rules kept feudal obligations intact, assuring that the lord will continue to be served by his own knights. When incorporated into English practice, the notion from Jewish law that debts could be recovered against a loan secured by all property, movable and immovable, was a weapon of socio-economic change that tore the fabric of feudal society and established the power of liquid wealth in place of land holding. The Crusades of the 12th century opened an era of change in feudal England. To obtain funds from Jews, nobles offered their land as collateral. Although the Jews, as aliens, could not hold any land in fee simple, they could take security interests of substantial money value. That Jews were permitted to hold security interests in land they did not occupy, expand interest in land beyond the traditional tendencies, the separation of possessory interests from interest and fee contributed to the decline of the rigid feudal land tenure structure. As the identity of the principals in the landlord-tenant relationship became less critical, a change in feudal rules restricting alienability of interest in land became possible. One catalyst of this change may have been a litigation surrounding the debt obligations to Jews secured by a debtor's property. The Jews in Norman England had specified legal status. They alone could lend money at interest. They were owed by the king, and their property was his property. The king suffered their presence only so long as they served his interests, primarily as a source of liquid capital. Because money lending by Christians was infrequent, English law had not established its own forms of security. The Jews operated within the framework of their own legal practice, which was based on Talmudic law developed over centuries of study. But the particular status of the Jews as the crown's de facto investment bankers encouraged the king to direct his courts to enforce the credit agreements made by the Jews under their alien practice. This nourished the growth of Jewish law in a way that blurred the absolutes of feudal land tenure. Previously inalienable rights in land gave way to economic necessities, and English ultimately adopted the Jewish practices. This note examines a moment of contact between two peoples, when necessarily proximity and social upheaval prompted a cultural exchange between the Jews, merchants, and money lenders and those they served. The note describes the effect on English law brought about by the king's Jews as they were executed and registered debt instruments, and enforced underlying obligations and generally survived money lending, the only profitable occupation open to them. It first reviews the Jewish credit agreement and its functions in Anglo-Saxon and Norman feudal society. It then suggests a rational explanation for development in medieval English law, heretofore perceived only as an anomaly, that in the early writs of debt, of which were for recovery of money, used terminology more appropriate to an action for recovery of land. This confusion now appears to be merely the linguistic expression of an innovation in the law due to the development of an action to recover alternative relief, repayment of money lent, or award of collateralized land. Finally, the note focuses on incorporation of Jewish law into English practice through a series of 13th century cases involving the same Jewish litigant. Jewish debt procedure had been thus become part of everyday business in England. Even as the Jews began to be excluded from money lending, their procedures were adopted into the general English law during governing debt registrations and collection. In 1275, the statute De Judismo forbade the Jews' usurious practices. In 1285, 10 years later, the Statute of Merchants formalized the creditor remedies that paralleled the provisions of the Jewish Shetar. In 1290, which is 5 years later, the Jews were expelled, but their credit practices remained the same. Now, I'm going to go a little bit further. The law of the Shetar, this is Jewish credit agreements in feudal England. The Shetar and Jewish law. The law of the Shetar development elaborated by 500 AD, showing you that this is going back a lot further than you know. The Babylonian Talmud antedates the Norman conquest by 6 centuries. Historically, the Shetar Hove, or generally just Shetar, was an instrument that established formal obligation, either in contract or in debt. At the moment that a debtor acknowledged his indebtedness to a Shetar, a general lien was established, encumbering all of the debtor's property as security for ultimate repayment. In case of default, the creditor could proceed not only against movable and immovable property held by the debtor, but also by and against the encumbered land that the debtor had transferred to a third party. The debt attached to the land and the creditor's lien had priority over subsequent alienations. Because of the severe obligations imposed by the Shetar, the contents of the instrument follow a standard form designed to ensure authenticity and precision. Each Shetar recited standard clauses of obligation, the creditor's right to customary modes of execution, and a final phrase stated that the document was not merely a form, but a statement of an express contract. And now you understand the direct and implicit Constitution, and you understand what the Declaration of Independence was. Inserted into the form language were the names of the parties, the sum and the currency of the debt, and the date of the obligation, thereby indicating the creation of the Lien, which is America, 1776. To prevent fraud, the document was signed by 2 witnesses who knew the parties. A nation of wanderers in adapting to a variety of cultures determined that the language which its Shetar was written should be irrelevant to its legal validity. Thus, in dealing with the surrounding Gentile populace, Jews content that loan agreements be formalized in Latin or in the Norman French or early England. Generally, the Jewish parties and witnesses would attest in Hebrew and the Christian in French or in French language, or in Latin. Although neither party may have understood the other's language, the document had the full force of law in both communities. The crucial limitation on debt collection under Jewish law was that a creditor had a lien against his debtor's land, but not against the debtor's person. Personal freedom was not to be diminished by debt obligation, and a creditor could not enslave one who was able to repay him. The origin of this practice was the biblical protection of the dignity of debtors, as embodied in the injunction not to enter into the debtor's home to receive a pledge, but rather to wait outside for the debtor to bring it out. This was the structure of law of obligation that the Jews brought with them to the English law. Normans in England, centralizing monarchy. Unique among its feudal neighbors, the Norman duchy was governed as a centralized unit with no baron strong enough to challenge the duke's authority. Although the Norman duke owed fealty, which is loyalty, to the king of France, that king lacked effective power over his vassals, who independently governed their own territories. Now, these are the people who they call today the working class citizens. Still the same system in the neo-colonialist system, who independently governed their own territories. In Normandy, however, feudalism was strictly territorial. A pyramid of land tenure embodied a system, notice that key word, pyramid, of military obligations ascending from knight over to baron to duke, from all whom had land, and all whom all authority derived. On the continent and later in England, William the Conqueror set out to maintain and strengthen this Norman system of centralized governance. With the conquest, the Normans introduced to England a well-organized central territory. The early authority and governance of conquered England concentrated power on the king. As William Conqueror imposed the rigorous order of the feudal system, he avoided the system's tendency toward the decentralization and disintegration that had sapped the power of the French kings. He limited the power of his tenants in chief by granting each of them land holdings and scattered over the realm, instead of large contiguous tracts. He governed the counties through sheriffs who depended on him for their power. He maintained a national militia thereby shunning total reliance on the loyalty of his tenants in chief. And he had all the significant landholdings swear an oath of primary allegiance to him. This concentration of power in the monarch grew during the successive reigns of a series of strong kings who increasingly assumed more power, military, legislative, and judicial power over the nation. And you just learned a very significant truth in less than 20 minutes. The reason why I elaborate more on history as opposed to tax documents, as most people wish for me to do videos on tax documentation, when the time comes for me to do that, I will do that, according to the design, specifically according to how my creator leads me to do that. That's not important right now. What's important for me on my channel is the primary historiological basis on why you are in the situation that you're in today. This is not something that was done overnight. Sheriffs existed in 1295. Sheriffs exist today in 2020. The same system has held sway over the entire populace of people worldwide for quite a long time. The centralization comes from this power from people being ignorant to how it works. Since you don't know how it works, you go by what it says. Since you don't know how it works. Now notice that it said that they could put a lien against the property, but not the person. Now we're getting down to the basis of why I emphasize and structuralize the UCC1 process on my channel so heavily. Because as long as it's not against your person, you can never be held liable for any debt. The property is a negotiable thing. That's negotiable. That's one of those situations where you have to wrest it from the hands of the individuals who actually manipulated it from you, whether you wish to put forth that effort or not. It is what it is. If you don't, please cut this video off and go watch something else. But if you do, you know what I'm saying, you are in that capacity to basically be aware of what I'm saying is a fundamental fact, please understand this as well too. I'm the type of person like this. Whether people believe what I'm saying or not, it doesn't matter. I'm reading from an authenticated source. Authenticated. A lot of footnotes, a lot of cliff notes in there, which can't elaborate on, but I had to be contacted by email for that. Period. I'm not going to do it online because, like I said before, informing people and also letting people know about something for educational purposes and personal reference and study are three separate prongs. So when it comes down to the elaboration of what I'm saying, yes, I have to be very general on this channel, for goodness sake, for my goodness, and I also elaborate on this because, like I said, you have to understand the historiological basis of your purported enemy, because if you don't, then their tactics will always work against you, because as long as they can keep you in a state of imposed ignorance, they got you lock, stock, and barrel. It's the truth. And also to mention, some people who have been a little bit, indolent about their commercial processes, I suggest by me addressing you in these manners, you're becoming more aware of something, and now that you're becoming more aware of it, you should also be more proactive about it. Don't just sit here and listen to what I'm saying. Listen to the words I'm trying to tell you according to the facts and information I transmit to you, and apply it. Some people have the assumption that it's hard. It's not. What's hard is enduring what you have to endure. That's hard. Enduring what you have to endure, that's hard. But the reality has been flipped for people to think that it's easy. Well, if suffering is easy for you, then I'm sorry. If you subscribed, I suggest you unsubscribe, because not only are you putting a necessary burden on your life, you may try to incur an unnecessary burden on mine. And I will never let no one do that to me whatsoever. However, these are fundamental truths that I speak about, and I won't stop. Can't break me, system, because you didn't make me. So as long as I keep doing what I'm doing, and keep maneuvering how I maneuver, and keep pushing how I push, and keep doing what I do, and keep speaking the delightful truth, I'll be quite all right. But for the viewers and subscribers, if it's your first time viewing these videos, Please hit the like and subscribe button so you can get these notifications whenever I upload on various topics, because we're going to cover a whole span of topics. And yes, this will continue for a very long time. Take care. Peace. I love y'all. Agents, you know what it is. Peace.